More than 27 million homes in England and Wales are now registered with HM Land Registry. And still, every year, criminals manage to steal houses that were never registered in the first place because the owner believed something that simply isn't true. Here's the belief I want to clear up right away. A lot of homeowners think that registering their house hands ownership over to the Crown, that their name gets swallowed up by the state and they lose some invisible layer of control. That isn't how it works. The law splits ownership into two parts, the registered owner and the beneficial owner, and you stay the beneficial owner either way. You keep every pound of value the house is worth. Registration doesn't take anything from you. It's the opposite. It protects you. By the time this video ends, you'll understand exactly why that distinction matters and why skipping it is one of the easiest ways to leave your own front door unlocked, legally speaking. If you own a home, there are 5 things worth doing now, and the first one gets skipped more than any of the others, purely because of that Crown ownership myth. Before I unpack the myth properly, I want you to see the actual numbers behind the risk. Once you've heard them, step 1 stops feeling optional and starts feeling like common sense. If you're 55 or older and you've spent decades paying off the house you're sitting in right now, stay with me for the next few minutes. I'll walk you through each of the 5 steps, one at a time, and show you exactly what closes the gaps that paperwork, and sometimes plain bad luck, can leave open. If you're a homeowner in the United Kingdom and you want to protect the property you've worked most of your life for, hit subscribe now. I'll go through every one of the 5 steps before this video ends. Let's start with the one people get wrong most often. Let's start with the number that should worry anyone who still hasn't registered their home. In the last full year on record, HM Land Registry stopped 97 attempted frauds before they went through, protecting more than £58 million worth of property. That's just the ones they caught. And the pattern behind those cases keeps repeating. Most of the successful frauds that do slip through happen on properties that were never registered in the first place. Here's why that gap exists. Right now, more than 27 million titles are registered in England and Wales, covering around 90% of the land. That other 10%, the unregistered slice, is where a fraudster has the easiest job. If your home was never registered, there's no official record of who legally owns it. A criminal only needs to forge one signature and gather a handful of copied documents, and they can pose as you to a solicitor who has nothing to check their story against. I need you to hear this next part clearly, because it's the belief that stops most people from registering in the first place. HM Land Registry holds what's called a register of title. That's a public record of who the law recognizes as the owner of a property. That owner is you, not the Crown. The Crown doesn't gain anything from your registration. The legal term for what you keep is beneficial owner, and it means you still hold the full economic value of your home, every bit of it. Registering doesn't hand anything over. It creates a paper trail that makes it much harder for someone else to pretend to be you. Think about what that paper trail actually does. Once your home is on the register, any future sale or mortgage against it has to go through an identity check tied to that specific record. Without it, a solicitor acting for a buyer has far less to verify you against, and that's exactly the gap fraud moves into. Here's the trade-off most people never think about until it's too late. Staying unregistered costs nothing today. It feels like doing nothing is the safe choice. But the real cost shows up later, quietly, when a fraudster forges paperwork while you're in hospital, or traveling, or simply not checking the post for a few weeks, and you only find out once the locks have effectively already changed hands on paper. Registering costs you an afternoon of admin now, in exchange for closing that door permanently. I'll admit something here. I used to believe the Crown ownership myth myself. There was an old house in my family that had never been registered, and for years I was hesitant to put it on the register because somewhere I'd picked up the idea that doing so meant giving something away. Then I sat down with a solicitor for about an hour, and she walked me through exactly how registered and beneficial ownership work. I'd had it backwards the whole time. I registered the house, and within about a year I received an alert that someone had tried to file paperwork against it. That's the part of the story most people don't get to see, because most people never register in the first place. It costs nothing to check whether your own home is already on the register, and it costs nothing to add it if it isn't. But once you are registered, how do you actually find out if someone tries to interfere with it? That's step 2, and it's also completely free. Step 2 is the Property Alert Service, and it's the part of this list that costs you nothing, not even time, once it's set up. Once your home is registered, you can sign up for a free alert from HM Land Registry that emails you the moment anyone makes an application against your property. A mortgage, a transfer, a new restriction, any of it. More than 770,000 people already have this switched on across England and Wales, which tells you it's not some obscure trick, it's a mainstream precaution that most homeowners simply haven't heard of yet. Setting it up takes about 5 minutes, and you can monitor up to 10 properties on a single account, which matters if you're also watching a parent's house or a property you've inherited. If the search doesn't find your home straight away, it's usually because the address is listed under a slightly different format than the one you'd expect, a house name instead of a number, for example. So it's worth searching by title number if the address search comes up empty. Here's the trade-off with an alert on its own. It tells you when something's happening. It doesn't stop it from happening. If you're away or unwell, or you simply don't see the email in time, the window to object can close before you've had the chance to act. An alert buys you information. It doesn't buy you certainty. Most people assume nothing will happen to their house, so they skip the alert entirely. That's a completely normal way to think, but it's also exactly the gap that lets fraud go unnoticed for weeks at a time. An alert doesn't stop someone from trying. It makes sure you're the first to know when they do, while there's still time to object. I thought the property alert sounded like overkill until the afternoon I actually got one. Someone had tried to register a charge against a property that belonged to people close to me. If that alert hadn't existed, none of us would have known until it was far too late to do anything about it. I'm not exaggerating how close that felt, but registration and alerts only tell you when something is happening. They don't stop a fraudster from trying to sell your home out from under you while you're not looking, especially if the house sits empty for stretches at a time. That's what Step 3 is built to prevent, and it comes with one trade-off worth knowing before you apply for it. Step 3 is about protecting your home while it's sitting empty, whether that's a holiday let, a house you've inherited, or simply the place you live while you're occasionally away for weeks at a time. It's called a Form LL restriction, and it does one very specific job. Once it's on your title, nobody can sell or mortgage your home without a solicitor formally certifying that the person signing the paperwork is genuinely you. No certificate, no sale. HM Land Registry won't complete the application without it, and here's the number that makes this worth doing. It costs nothing to apply. You fill in a form, you send it in, and it sits on your title indefinitely, quietly doing its job in the background. Picture the exact situation this is built for. Say you're in hospital for a few weeks, or staying with a son or daughter while you recover from something, and your house is standing empty. A fraudster who's done their homework can see the property looks unoccupied. They gather up a few forged documents, approach a buyer, and without a Form LL restriction on the title, there's a real chance the sale goes through before anyone catches it. With the restriction in place, the buyer's own solicitor has to stop and verify who's actually behind the signature. That single step is usually enough to catch the forgery before money changes hands. Now for the trade-off, because there is one. When you eventually do want to sell or remortgage the house yourself, that same identity check applies to you too. It usually means a bit more paperwork for your solicitor, a short delay while the certification gets done properly, and a modest additional fee on your legal bill. That's the price of the roadblock. It only slows you down. For a criminal trying to move fast before anyone notices, it can stop them completely. I understand why this feels like unnecessary admin at first glance, Nobody wants another form to fill in. But property fraud is almost always a crime of opportunity. It targets the house that looks easiest, not the house that's best protected. Adding a Form LL restriction takes one form away from the criminal side of the ledger and adds a genuine obstacle in its place. Now think about a different kind of gap, one that has nothing to do with fraud. Say you're married, or you've been with a partner for decades, and one of you loses the ability to manage money or make decisions through illness, an accident, or something like dementia. Registration, alerts, and a Form LL restriction won't help you there. Step 4 is what closes that gap, and it also protects your family from a process most people only discover exists once it's already too late to avoid it. Step 4 has nothing to do with fraud. It's about what happens if you or your partner lose the ability to manage your own money and property, whether that's sudden, through a stroke or an accident, or gradual, through something like dementia. It's called a lasting power of attorney for property and financial affairs, and what it does is simple. It lets someone you trust step in and manage your home, your bank accounts, and your bills if you're no longer able to do it yourself. Without one, nobody, not even a husband, wife, or grown-up child, has an automatic legal right to access your accounts or make decisions about your house on your behalf. They'd have to apply to the Court of Protection instead, and that's a very different experience. Here's the actual cost comparison, because this is where the numbers do the talking. Registering a lasting power of attorney costs £92 per document. So if you set up both the property and finances version and the health and welfare version, that's £184 in total. It usually takes around 10 to 12 weeks from application to registration. Compare that with the alternative. If nobody has an LPA in place, and a family member has to apply to the Court of Protection instead, the application itself costs more than £400, and the whole process often takes the best part of a year, sometimes longer, while your accounts and property sit frozen in the meantime. A bit of history helps explain why this matters so much. The Mental Capacity Act became fully law in 2007, and it's what created the modern, lasting power of attorney. Before that, families only had access to a far more limited document called an enduring power of attorney, which covered a lot less ground. Even now, with a proper legal route available, a significant number of people lose mental capacity each year without ever putting one in place, and their families end up locked out of the very accounts they need to pay the mortgage, the care fees, or the electricity bill. I understand the instinct to put this off. Most people think, I'm healthy, I don't need this yet. That's a completely normal way to feel at 55 or 60. But an LPA only works if you set it up while you still clearly have the mental capacity to do so. Once a diagnosis like dementia is confirmed, it can already be too late to register one, and the only door left open is the slower, more expensive one through the courts. You've now got 4 layers of protection stacked on top of each other: registration, alerts, a restriction, and a lasting power of attorney. There's one more piece most couples get wrong, and it has nothing to do with fraud or capacity. It decides who actually ends up owning your home after one of you dies, and whether the council can count the whole thing against you if the other one later needs care. Step 5 is the one that decides what actually happens to your house after one partner dies, and it trips up more couples than any of the other 4 steps combined. If you and your partner own your home as joint tenants, which is the default and by far the most common setup, the surviving partner automatically inherits the whole property the moment the other one dies. On the surface, that sounds like exactly what you'd want, but it also means the whole value of the house now sits in one person's name, which matters enormously if that surviving partner ever needs to go into residential care. Here's the mechanism, and I want to walk through it properly, because there's a myth here almost as persistent as the Crown ownership one from earlier in this video. A lot of people believe there's a fixed window, often talked about as 5 years or 7 years, after which gifting your share of the house to your children becomes completely safe from council scrutiny. That isn't how the rules actually work. Under the Care Act, there's no fixed time limit at all. A council can look back as far as it needs to. What they're actually assessing is intent, whether avoiding care costs was a significant reason behind the gift, and whether needing care was a foreseeable possibility at the time you made it. Hand over your share the week before you go into a home, and it's an obvious case. Do it decades earlier, for reasons that clearly had nothing to do with care planning, and it's a very different picture. There's no shortcut number that makes it automatically safe either way. Now for the mini-math that actually matters here. The capital threshold for means-tested council help with care fees in England is £23,250. Above that, you're expected to fund your own care in full. Residential care currently runs well over £5,500 a month on average. More for nursing care, which is well over £6,500 a month. Do that arithmetic and a single person's savings can be gone in well under a year once the family home's full value gets counted as an asset. This is where tenancy in common comes in, alongside a properly drafted trust arrangement, sometimes called a life interest trust, set up through your wills rather than through the land registry alone. Instead of automatically inheriting the whole property, you each own a separate, defined share. When the first partner dies, their share can pass into a trust for the children, while the surviving partner keeps the legal right to live in the house for as long as they need to, because that share technically belongs to the trust and not to the surviving partner personally. It generally sits outside what the council can count as their asset if they later need care themselves, though the details depend on how the trust is written, and it's worth getting a solicitor to set this up properly rather than relying on a template. I know talking about one of you dying first isn't a comfortable way to spend an afternoon, but putting this conversation off doesn't remove the situation. It just means nobody's prepared for it when it actually happens. My partner and I were joint tenants for about 20 years because it was simply what everyone around us did and nobody had ever explained there was another option. When I finally learned about tenancy in common, I felt a bit foolish for not looking into it sooner. We changed ours not long ago. It took one letter to the land registry, and it cost us nothing beyond the solicitor's time to set up the trust properly. Those 5 steps: registering your title, switching on the free alert, adding a restriction, putting a lasting power of attorney in place, and changing how you own the house with your partner, they build a genuine wall around the home you've spent your working life paying for. There's one piece left that ties all 5 of them together, and it's the one most people assume they've already sorted. Let's bring these 5 together, because on their own, each one sounds like a small piece of admin, but stacked up they change what's actually possible for someone trying to take your home, whether that's a criminal or simply a system nobody explained properly. Registering your home with HM Land Registry replaces a gap in the paperwork with a public record that says the house is yours. The free property alert service means you're the first to know if anyone ever tries to interfere with that record. A Form LL restriction forces a solicitor to check that whoever's signing your paperwork is genuinely you. A lasting power of attorney means someone you trust can step in and manage your home if you're ever unable to, without a court getting involved first. And changing from joint tenancy to tenancy in common, with a proper trust behind it, protects at least half the value of your home from being swallowed by care costs after one of you is gone. You've worked most of your life for that house. You paid the mortgage for decades, you kept the roof sound, you covered the stamp duty when you bought it. You should be able to live in it for as long as you choose, and pass on what's left of it to the people you care about, without a forged signature, an uninformed decision, or an overlooked form taking that choice away from you. None of this is about avoiding what you owe. It's about making sure what you've genuinely built stays where you intended it to go. If you've watched all the way to here, you clearly take protecting your home seriously, which puts you ahead of most homeowners your age. Subscribe if you'd like more of this. I cover the exact traps and the exact fixes that affect people like you across the United Kingdom every week. And if there's a friend, a sibling, or a parent in your life who owns their own home and hasn't done any of this yet, send them this video. These 5 steps could save them tens of thousands of pounds, and in the worst case, they could save the house itself. Thanks for watching, and I'll see you in the next one.